Okay, we're going to continue with privacy. We talked about how privacy can be sacrificed for the public good. And one of the important public good was the need for criminal investigation. And criminal investigation is very important because it protects us from ourselves. It protects us from the more dangerous ones among us. So it is justified infringement on privacy. But for the state to benefit from that exception, that justification, it has to protect people with a presumption of innocence. So people presumed to be innocent cannot be restricted on their rights before they are proven to be guilty. But how do you do criminal investigation when the really bad people will just avoid investigation? I mean, how do you prove someone guilty if the person will refuse to come to a trial, refuse to bring in incriminating evidence? So there has to be some mandatory way of finding out about people, finding out the bad behaviors of other people, and that procedure is called warrant. So we talked about how warrant is very important. Warrant is the requirement for the state to infringe someone's privacy for the purpose of criminal investigation. And also, the due process requires that when the warrant is executed, it has to be done through procedure that makes sense. For instance, let's say the police have a warrant to search my house. Can the police just come into my house secretly without letting me know, like thieves? That cannot be, right? I mean, when the state does something for public good, it has to let people know why they are doing it, and that they are doing it, and when and where they are doing it. They cannot do it secretly. So there is this due process requirement that warrant be presented upon execution. Now, before I go into how privacy infringement can be justified in the name of criminal investigation, let me track back a little bit about what privacy is, just one more time. Okay, these are the wedding pictures of Michael Douglas and Catherine Zeta-Jones, two probably one of the most famous actor-actress couples in the world. And of course, there were many media companies that wanted to cover the wedding, but they held a secret wedding and gave the exclusive right to this magazine called OK, a British magazine, for some enormous amount of money, for like $20 million. Probably the wedding didn't cost $1 million, but they sold the exclusive right to take photographs at their wedding to that magazine for much greater amount of money, and banned everyone else from coming into the wedding, not to mention taking photographs. Now, this magazine, this rival magazine, Hello, heard about the wedding, but was angry that they didn't get to buy the exclusive right. So they also try to, so what they did was they went in mocking as a guest and secretly smuggled in a camera and took these snapshots. Because these are snapshots, you see, I mean, the shots are not that great, but those are the snapshots of the wedding. So this magazine, Hello, they published the photos that they secretly took on the same day that OK published their licensed photos. Michael Douglas and Catherine Zeta-Jones sued Hello for invasion of privacy. What do you think should be the result? Is this invasion of privacy or not? Some may think that, hey, this is a wedding, the photos of which are published on another magazine, right? What's so private about this wedding? I mean, yes, it was private before the photos were published, because nobody knew what went on inside other than the families. But once it got published, or at least simultaneously upon publication, now what happened in the wedding is public matter. What's wrong with taking few more photographs or publishing few more photographs? But the court said this is invasion of privacy because there is really no public interest. There is no public interest that justifies the unauthorized entry into the wedding venue. And there is no public interest in publishing the photos taken there. Okay. Now, I'm telling you about this case because when you talk about privacy, you think about sexual orientation, blood type, your medical health records, or your academic grades, which you don't usually share with other people. But even if the content itself is not of such private nature, as long as you held privately within your domain, as long as you withdrew from other people's eyes, then it is still considered private. For instance, it's raining outside. No, it's not. But just assume that it's raining outside. And you write an email to your friend that, oh, it's raining. Now, if the police want to find out, if the police want to search and seize the content of your email, is that privacy infringement? Is that infringement on privacy so that the police need to get a warrant? Or is it not privacy because the fact that it's raining outside is something that everybody knows? What do you think? Privacy, right? Because the fact that it's raining outside may not be private, but the fact that you know that it's raining outside, that's private. Understand? So that's why I call this spatial privacy as or topological privacy. Topology, if you studied math, you know what I'm talking about when I say topology. It's a study of space. Spatial means, you know, as opposed to temporal, concerning space, right? So what's private does not depend on the content, but where it is. If it is within a privately held space, then it should be protected as private. Yes? Okay. Let's go back to the justification for breaching, or the states, the government's justification for breaching privacy. So we talked about different levels of state surveillance. And depending on how infringing, depending on how severe infringement is, the level of procedural requirement, that the government has to satisfy varies. Okay? So content versus metadata. We talked about this. This was the last item we talked about in the last class. Okay? Now, let's say the police want to eavesdrop on your phone conversation with your friend. That's content. Or the police want to find out who you talked to last night, or in the past 24 hours. How many people you talked to, whom you talked to, for how long, when. Which one is more infringing on your privacy? The content of your phone conversations, or the time duration, your phone conversation, the identity of your phone conversation partners? Which one is more privacy infringing? Content, right? Now, the time, place, duration, the identity of your communication partners, those are all called metadata. It's called metadata because that's not really the real data. That's not really the substance of communication, but it's the information that's needed to make the communication work. For instance, so by the way, it's not the identities of the communication partners that are metadata. It is the phone numbers of your communication partners that you spoke with. So what the police do is they get the phone records from a phone company on your account, and they get a list of the phone numbers indexed with the time of making the phone calls and the duration. And that's metadata. And why is that protected less? I mean, you said it should be protected less than the content, but why is that? Well, number one, somebody else has the information. Now, your phone conversation, nobody else knows other than you and your friend. But the fact that you made those phone calls, somebody knows. Who knows? Somebody else knows that. Who should know that? The phone company, right? And the phone company need that information actually to connect you with your friend. Right? So these are the information that are needed to make the communication possible. And the phone company keeps a tab on how long you spoke with whom, so that they can do what? They can charge you money. All right? So these are the necessary, these are not just necessary enablers, these are necessary enablers of communication, but also byproducts of communications that need to be shared with the phone company. So the idea is that, hey, if the phone company can access the information, why not the police? Right? That's the idea. That's why metadata is protected less than content. Okay, the second item. Stored content versus real time. Okay. So let's say you sent an email to your friend, and the police want to get hold of the email content. That's one thing. Okay, access to your email content. Now, the police want to eavesdrop on your phone conversation. That didn't happen yet. Okay? They want to be listening in while you are talking. All right? Which one do you think is more privacy infringing? Getting the information in real time, or accessing the information that's already there? Real time? Second one, real time? Okay. What do others think? Well, many people believe that real time is more severe privacy infringement. You don't think so? Well, there is a minority of people who believe that accessing the stored content is equally or more severely infringing. But generally, wiretapping is considered much more serious infringement than accessing the content, accessing the stored information. One of the reasons is that accessing the email content can be justified by making an argument that, hey, incriminating information is there, or is likely there, right? The police can make that argument. But for a phone conversation that didn't happen yet, the police can make the argument, because when I pick up the phone with my friend, nobody knows what I'm going to say. Nobody knows whether that actually concerns any criminal activity. All right? So it's much more, it's much harder to justify real-time access to information than access to stored content. Now, how about mass surveillance versus individualized suspicion? What is mass surveillance? Mass surveillance is what happened with the United States government's NSA, National Security Agency. What they did was they didn't have any suspects, okay? They didn't have any suspects to do more investigation on. They were looking for suspects. So what did they do? They did mass surveillance. They investigated on everybody, like 20, 30 million people. Now, it will be impossible to get warrants on 20, 30 million people, because there will be 20, 30 million warrants. So what NSA did was they looked at only metadata, right? So who called whom? And the procedure for obtaining the metadata is much lower. Okay, the procedural bar for obtaining the metadata is much lower than obtaining the content of the communication. And just by looking at the phone records, right? Just by looking at the phone records of 20, 30 million people and figuring out who may be connected to or who may have some relationship to the known terrorist numbers, right? They try to identify suspects. So that's one way mass surveillance is done. So NSA, entered into a contract with AT&T, and AT&T turned over all the phone records of many, many people, so that NSA could do analysis. Okay, so this person made a phone call to this phone number in, this phone number in Damascus, the known capital of terrorism. I'm just kidding, right? And he repeatedly made those phone calls. And then the phone calls were to people that were previously, that had made phone calls to the known terrorist in Paris, France. And then there were, and then they were on the phone with hackers in Russia. So these people in the United States, who started this phone chain, must be related to some criminal activity. So we will identify them as suspect. That is mass surveillance. So usually surveillance is based on individual suspicion, right? Surveillance is done on a probable cause. Probable cause that this somebody is suspect. Okay, so this somebody is suspicious of conducting criminal activity, and this person must be investigated, or this person is suspicious of criminal activity, and his email content is likely to contain some incriminating evidence. Therefore, we are justified in infringing on this person's privacy. That's usually the logic of surveillance. But mass surveillance starts when they don't have a suspect. Okay? Classical surveillance starts when they have a suspect and they want to find out more. Okay? So they prove individualized suspicion, person by person, and then do more investigation. But mass surveillance, you just indiscriminately get the data on huge number of people to identify suspects. Now, that's real mass surveillance, but there is kind of a quasi-mass surveillance that happens a lot. Let's say a murder happened at point A, okay? And very similar murder happened at point B, okay? One way the police to the investigation is to get the list of phone numbers that made remote connections to the mobile access points around point A, right? And then get the, what I mean by access points are, when you use a mobile phone, there are antennas that make connections to your mobile server, right? And your phone, even when you are not using it, like every 7 or 8 seconds, it keeps sending signals to the nearest AP, access point. It's also called a cell tower, right? So probably there are several cell towers within this building. That's why you can use your phone without much interference, without much difficulty, right? Because there is abundance of bandwidth available in this building. So anyway, so if a crime takes place at point A, they get the list of phone numbers that made the connection that connected with the cell towers in area A, and then they get the similar list for area B, where a similar crime has taken place, and they compare. And if there are numbers that show up in both places, what would you do if you are the police officer? You will have a suspicion, right? You will have a suspicion that the owners of those overlapping numbers may be related to the crime, right? So, but you may call it mass surveillance, you may call it individualized suspicion, but I mean, there is always a possibility that, you know, some people went to those places for innocent reasons, right? Let's say the crime is bank robbery, right? And how about there are people who have accounts in both banks? They have innocent reasons. They have entirely innocuous reasons to be at both places. So they are pulled in. They are investigated for no reasons, you know, from their perspective. So that can be also called mass surveillance. Although there is some narrowing down from the general public down to a small number of people who have special features. Special feature meaning being at both places, being at both scenes of crime. Okay. And how about obtaining the GPS data versus IP address or mobile AP data? Okay. What do I mean by this? Now, mobile AP data is the cell tower data, right? For instance, what cell tower? So the police can get hold of the list of phones that connected with the cell towers, but they also can get the list of cell towers that your phone connected with past 24 hours or 30 days, whatever. Now, if they can get a list of cell towers that your phone connected with, what can they get? They can get your location, right? Now, what procedure is needed to justify obtaining your location, right? The cell tower location cannot pinpoint you within, like, you know, cannot pinpoint you within, 5-meter circle or anything like that. Cell tower location can only place you, say, within about a radius of 1 kilometer, right? Because the reach of the connection between cell tower and phone can be as long as 2-3 kilometers. So you don't get, by get the cell tower location information, the police do not get accurate location information. They just get a general idea of your whereabouts. Okay. How about IP address? IP address for, I guess, for this one, PC, right? For the police to get the IP addresses that you connected to, right? Or the IP address that you logged on, that also allows the police to obtain your location, because each computer has IP address. And let's say you used Google, and if the police goes to Google and get a list of IP addresses from which you logged on to Gmail, then they can get also list of locations. They can get a list of locations, or at least a list of computers from which you logged on to the Gmail server. So that also is revealing of your location, right? How about GPS data? That's much more accurate. Okay. GPS can locate you within like 2-3 meters radius. GPS is now the yes. Let's just stop there on GPS. So in terms of accuracy, GPS data can pinpoint your location. IP address can pinpoint the computer that you logged on, from which you logged on to the server. Cell tower location can locate you within 2-3 kilometers radius. How much should the state prove to get your location data, right? Do they need a warrant? Do they need something like a probable cause to believe that I'm connected with a crime to get my location? Or is the location data something that's not so privately held, because, hey, when you walk out the door right now, everybody sees you that you are there. When you go on subway, when you get on bus, people are there to see you. You're not keeping it private. Well, if fellow passengers on your buses and subways, if they can know your location, why not the police that have a very important job to do, right? Now, these are the questions that some governments believe have solved, and other governments have not. So there's a lot of ethical debate about this. Now, the US government believes that accessing metadata doesn't mean much. Okay? Because metadata is something that, something like address on the envelope. Anybody can see it, and anybody should be able to see it to deliver, to make sure that the envelope gets to where it should go. That's why NSA engaged in the mass surveillance, because they thought that they were just accessing metadata. All they wanted to know was when, for how long, with whom you were on the phone. That's all they wanted to know. That's not much of your privacy. It's something that your phone company should know. Why not NSA? We are fighting terrorists. That was the logic behind the Snowden revelation. Well, that's the logic behind the surveillance, NSA surveillance revealed by Snowden. So, and also, Korean governments believe that identifying or finding out about the identities of people that you spoke to also does not infringe much of their privacy. What I mean is this. Let's say a suspect was brought in for legitimate reason, with a warrant, with the probable cause, all of that, all the procedural requirements are met, and he has a phone, right? And on the phone, there is a record of phone numbers that he has called right before commission of the crime. Now, the police, for whatever reason, although they already got the suspect, the police, for whatever reason, decide to unmask, right, to get the identification information of the people that the suspect has spoken to, right? So so if I spoke with a suspect, right before the commission of the crime, although I had that phone conversation believing that it is an anonymous communication, or it is a communication that nobody knows about, it's a communication that nobody knows that has happened, the police will now have the information that I was on the phone. So that type of unmasking, that type of getting the identity of the people who spoke on the phone or people who put something online, that happens in mass in Korea. 10 million times a year in a country of 50 million. That's every year. Watch this video clip. Okay. The man giving the flower, giving the wreath of flowers, is the Minister of Culture and Sports. And the one receiving the flowers is none other than, Yeona Kim, the figure skater, gold medalist in some Olympics, I don't know which. So she came back and she's being greeted by the minister because she's a national hero. Watch next few seconds. Do you think he wanted to give him a hug? Give her a hug? Do you think he wanted to give her a hug, but she was avoiding him? That's hard to tell. But some people who didn't like the minister made this video viral, attaching a message that Yeona is avoiding the minister. Okay? And the minister got so angry and filed a criminal complaint for defamation. But against whom? Because on YouTube, it is run anonymously. The minister doesn't know who has uploaded the video, right? So what did he do? He went to the police and filed a criminal complaint, and the police went to not YouTube, well, it is a YouTube video, but it was, so the real YouTube videos could not be accessed because Google will not respond to the police request for identification of the users. But there was the same video that was uploaded on a domestic portal, Naver. The police went to Naver and demanded the identity of the person who uploaded the video, and Naver gave it up. That is one of the 10 millions I'm talking about. Now, what do you think? Do you think that unmasking an anonymous netizen like that should be done without judicial oversight, without court's approval, without a warrant? Or do you think that is something that the police should be able to do without getting approval from the court or any other official? What do you think? Being unmasked, right? So you are on the phone believing that you are an anonymous person. You go online believing that you are anonymous, but now your identity is forced into disclosure, at least to the police. Is that something that the police needs to justify by going through the warrant process? Or is it something the police should be able to do without such procedural requirement? What do you think? I mean, you can think of it this way. Let's say you are walking down the street and the police come to you and demand your identification. They want to identify you. Do you think that the police should have some substantial reasons to do so, or should be able to do it anytime they want? Okay, think about it. Think about it. So these questions, you know, which investigation techniques involve or infringe, how much privacy and how much justification is needed for those investigative techniques are still up in the air. There is much debate, a lot of lawsuits and constitutional challenges. But the majority believe that wiretapping, okay, real-time access to the content is the most severe, and accessing the stored content is next to severe, and accessing the metadata real-time is next to that, and the least privacy infringing is stored metadata. And stored metadata includes the identities of the users, and that's why like 10 million unmasking is taking place every year in Korea. Necessary and proportional principles are one attempt. There's a link on Blackboard. You can go through that. There's a lot of good language there. Necessary and proportional principles is is a document that 500 NGOs around the world have subscribed to establish what they believe is a fair procedure for government surveillance. And they, so one of the central arguments of necessary and proportional principles is that even accessing the metadata can be severe infringement on privacy and should be backed up by a warrant process. Okay. I mean, one of the arguments that they make is, hey, listening, eavesdropping on my phone conversation, that's privacy infringing, but if you know my locations, right, By getting a list of cell towers that my mobile phone connected to, they can get locations, right? If they can get location data of me, they can pretty much figure out what I was doing, right? If they can locate me in a school, they can figure that I'm studying or teaching. If they locate me at a public bath, they don't have to actually come in. They don't have to actually, look at the content of what's going on to infer that I'm taking a bath, right? A lot of inference can be made from just getting the locations, and a lot of inference can be made just getting the metadata. A lot of inference can be made from whom you have spoken, whom you have phoned with. That's just as revealing as the content of the communications. That's the argument. So read through the principles. So ethical questions remain. We went through some of them, but we'll go through each one more time. So usually the question is, how much probable cause is enough for state surveillance? And how much public interest is substantial enough to justify private surveillance? Here, not state surveillance, but private surveillance, right? Even private surveillance can be justified. What I mean is, for instance, we talked about this. I want to find out whether my neighborhood eye doctor is over-diagnosing or over-subscribing pills. Then, I may want to find that out by impersonating as a customer and going in and go through some operations and get the information that the doctor otherwise would not have disclosed. That's kind of a surveillance. And that also needs to be justified. That also needs to be justified by the public interest of whistleblowing, right? Public interest of whistleblowing on medical greedy practices of eye doctors or something like that. Now, ethical question, is metadata really private? We talked about this, right? Now, how can you limit surveillance to necessary extent when all information look the same? What are we talking about? These days, the information in all walks of your life can be concentrated in one device, in one physical space. What is that? Your mobile phone, or your notebook computer. Or if you have a PC that you use a lot at home or at work, those personal computers become the depository of information about, depository of your medical records, your education records, your library records, your family records, all of that. Now, if a judge issues a warrant to access the PC or mobile phone, all that information will be made available to the police. Okay, that's not fair, because let's say I'm being investigated for smoking marijuana. Let's assume that I am. But why should my information about, why should the information about my family or my academic records be made available to the police? Right? So usually a judge will write on the warrant that, hey, you, the police officer, when you search, okay, you are authorized to search K.S. Park's hard disk, but when you do that, just look at the files, but don't look at the files that concern, his unrelated family matters, right? Just look at the files that look like having some connections to use of marijuana. But the thing is, when the police open up the hard disk, all the information look the same. They are all computer files. Everything on the computer is just a file, right? Now, if they look for some physical incriminating evidence for use of marijuana, they look for, some snubs of dried weed, or some paper that I used to roll, or the glass bong that I used to smoke, right? And the police will just look for that. And they can limit their search to the physical spaces those things can appear. But when the police go into hard disk, everything looks the same. Everything is just a file. So it's very difficult to limit search within the computer. So there's one big debate, global debate, between the police who believe that, okay, now search is more difficult, so we should just search the full hard disk, right? We cannot distinguish a picture of marijuana from picture of the suspect's grandchildren. We'll have to open up all the files. That's the police argument. The other side, hey, you still can make efforts to limit your search. Do the name search. Do the search by name of the files. And if the name of the file includes something like weed, hey, you can just open those up. But I mean, what kind of drug user will name their photos weed, right? But still, there is a need to limit the search within the computer, and there is a big debate on that. Now, one ethical question that we didn't talk about is Apple versus FBI. There was a lone wolf attack by a follower of ISIS in Southern California against health workers in a certain health facility. Something like 10 people were killed in a shootout. And he was killed himself. FBI got hold of his iPhone, but it was locked. It had, how many of you used the phone with a password locked? Yeah, most of you, right? Well, most women. And there's no way in hell that they can unlock the phone, so they go to Apple and demand that Apple decrypts, right, deciphers the phone so that the FBI can look at the content of the phone. And it is very, very important for FBI because, I mean, this is not a suspect. This is a known terrorist, right? It's not like a probable cause. This is certain cause. There's convincing belief that, well, not just belief, it is a fact that he is a terrorist. So FBI wants to find out his connections so that he can prevent further terrorism. Does it sound like a good public interest to justify privacy infringement? Yes. Yes, I think so. I think that they have justification to break into the shooter's iPhone, but the only problem is that FBI doesn't know how, doesn't have the technology to do so. Now, when that happens, is Apple obligated to provide the technology? That's one ethical question that has grabbed the news for a few months. You have a question about this? Okay.
Would they be forced to abide and help the government because of the Freedom Patriot Act?
Freedom?
Freedom Act? Patriot Act?
Patriot? Well, yes. The communication providers, communication service providers, have some obligations to cooperate with the police, but usually what happens is when the police have a warrant, it authorizes the police to do things, right? But usually the warrants do not force people to do anything, right? For instance, if I need to be searched, I can just stay put and the police will just search my body. But can the state order me to undress and make it a crime if I don't get undressed? Usually that doesn't happen because that's considered infringement on my freedom, right? If the state is empowered to do something, they should just do it without enlisting the individual's help. So anyway, Apple resisted the FBI's request for cooperation, and in the end, FBI somehow figured it out. So the ethical question was avoided after a few months. But if you read the article that I made the link to, my position was that making somebody write a new software, or making someone write a novel, making someone paint a picture, all of these things cannot be compelled by the state for whatever reason. If the state have reasons to do so, they should do it themselves. Okay. Should the parties be notified of surveillance? We already talked about this. How can you notify the users when people are anonymous? Well, that's, maybe we should change the order, right? This should go up. So the question, how can you, should the parties be notified of state surveillance? Of course. Okay, we already talked about this. But what if the users are anonymous, right? How can you notify them? That's one of the reasons, I mean, that's one of the arguments that the authorities make. when they fail to notify the users of the fact of surveillance. Well, this is not really an ethical question. This is a technical question. Well, I think that the notification be given to anonymous people, right? If the police know an email address of an anonymous person, they can just send an email to that person. This is not really an ethical question. Other questions. Which country's judges should approve surveillance on foreigners? Which country judge should approve surveillance overseas? Okay, this concerns you. Korean surveillance law is such that wiretapping on Korean nationals requires judge-issued order, but wiretapping on foreigners does not require judge-issued warrant. So if you are being wiretapped, there is no independent judiciary that's overseeing, that's making sure that your rights is not being violated too much. Why do you think that is? Why do you think that there is that discrimination against foreigners in Korean wiretapping law? Is it because foreigners are more likely to be spies, terrorists, and dangerous to the Korean society? Well, that's another ethical question. The fact of the matter is, it's not just Korean law. Wiretapping laws of the US and many other countries that claim to be the guardian angels of human rights, they all discriminate against foreigners in terms of procedural requirements for wiretapping. That's one of the provisions that I'm planning a constitutional challenge against. But some people believe that, hey, our job is to protect our country, and who is more likely to attack our country? Foreigners. So we'll make it easier to wiretap on foreigners than foreign nationals. What would you say to that argument? If you have nothing to say, then you should eat it. You should live with it. Okay. The next question is, which country's judges should approve surveillance overseas? Let's say the police want to do investigation on me, but I use Gmail. Now, if the police get a warrant on me, that cannot be executed on the Gmail server because Gmail server is in the United States. Does it mean that the police cannot do investigation on me even when they have a probable cause, even when they have a warrant properly issued from Korean judge, just because I use Gmail? Well, that's one argument. My argument is, hey, that's one of the reasons that I use Gmail. I don't trust our prosecutors. I don't trust our judges. I want more privacy. I want to make it more difficult for the authorities to infringe on my privacy. That's why I use Gmail. Which side should win? That's another ethical question. Finally, I know I'm over time. CCTV and social media profiling and doxing. Doxing, D-O-X-I-N-G, Google it up. Doxing means, doxing and profiling are the same thing. Getting all the information about a person through the information that he himself has made available online. Okay? Or any other publicly available information. Right? That's doxing and profiling. Some people believe that that's also surveillance, and that is something that should be regulated. For the same reason, some people believe that CCTV is also surveillance. CCTV in public places. But there are other people who believe that, hey, CCTV is not there secretly. It's usually, in a prominent position so that everybody knows that they are being watched. And when you put something online, Facebook or Twitter, then you are, releasing things out of your privacy. There's nothing more private there. Getting that, just collating that information, that's not surveillance. Who do you think should win on that ethical argument, on that ethical question? Think about it. The answers in the Kuocw talk, we didn't have time to discuss. In class, I'll just add answers on the Kuocw talk, okay? So check the answers to your questions. And I already uploaded the PPT presentation for this Thursday, and that's about data protection. And it has a lot to do with the last discussion we had about privacy. Okay, we'll end here. Thank you.